I'm just saying.
I had to go to a fundraiser, so that's all that's left.
This is perfect.
You watch
that
football?
stuff is really good.
Yes. Who's the worst team
I
in
haven't had it in a
football?
while. I forgot our
Oh, yeah.
The one
At the moment,
easily better.
historic. Is it
This is really good.
the Browns? Are they the worst now, or is it? Yeah. They're,
You know what
they're
else?
among them.
Yeah.
No, they're among them right now.
Years ago would be a coach for the squares with some of that. Yeah. There's a dark chocolate with sea salt and caramel one.
I haven't had the caramel.
Oh,
I'm ready when you get it.
Okay,
you're the one that's responded to that.
I'll have to try that one.
I'll bring it back.
Okay, we're about to get started. If you have a cell phone, please turn it off or silence it. I will call the work session of the City Commission for Wednesday, November 20th to order.
There it is.
Call the roll.
Commissioner Rachel Lyle Smith. Here. Commissioner Frank O'Donnell.
Here.
Commissioner Rocky Smith.
Here.
Commissioner Denise McGriff. Present. And Mayor Dan Holliday.
Here. So we have one discussion item on the agenda, 19652, voter approval of annexation, Senate Bill 1573, and Home Rule, Ms. Turway.
Thank you very much. I just want to acknowledge a couple of letters that were submitted, and they were provided to the commission in the record from Mr. Nacita as well as Mr. Buss. Mr. Kabaisman has a presentation, or wanted to talk to you a little bit about the material in the packet.
Thank you, Laura, Mayor, Commissioners. I'm not going to give a very long presentation. This is something that has been around the city for a while. There's a lot of background to it, and you got a lot of it in your staff report. Essentially, in 1999, the Oregon City Commission sent a measure to the voters to make all annexations voter approved. Voters approved that, and since that time, I believe all annexations were sent to the voters until 1753. Senate Bill 1573 was adopted in 2007. In the 2016 legislature became effective in 2017, which by its terms says, notwithstanding a contrary provision of the city charter or city ordinance, upon receipt of a petition proposing annexation of territory to all owners in the territory, the legislative body of the city shall annex the territory without submitting the proposal to the electors if the territory, and goes on to have those qualifications. After that was adopted in 2017, this measure, the legislation was brought to the City Commission. There was extensive discussions at that time about what it means and how the city would process it, and the commission settled on a policy that it would follow 1573 and would no longer submit measured annexations to the voters if that met the qualifications in that bill. Since that time, the city of Corvallis and Philomath, as well as a number of other cities, challenged Senate Bill 1573, alleging that it was unconstitutional. They lost in Benton County Circuit Court. That was appealed to the Oregon Court of Appeals. Argument was held in that in June or July of 2018, almost 18 months ago. A decision from the Court of Appeals could come out tomorrow, or actually next Wednesday. They issue on Wednesdays. Could come out next Wednesday, or it could be 6 months from now. We just don't know.
Give them one of those jobs.
We are not bound by the Benton County Circuit Court decisions. There are significant implications for home rule, for how the city operates, and we can get into those discussions. We can get into discussions about, what the measure means and how to interpret it. But it's really up to you. I want to turn it over to you to talk about what you want to do with the policy. There is a memo where I set out several options if you want to revisit it, or we can continue on the path that we're going now and waiting for decisions from the Court of Appeals or elsewhere. With that, I'm happy to answer any questions about any of the materials that are provided to you or other questions, and otherwise let you guys talk about what policy the commission wants moving forward.
And then the one thing we did add, so after the commission packet went out, we continued to just kind of try to find background. So we put on the dais here the special election measure 3-51 voter approved amendment May 18th, 1999. So that's what we were able to find as it relates to what was sent to the voters. If you look on the Clackamas County explanatory statement. So it's page 3, but like the second page since they're back to back. Second paragraph, last sentence. I think you'll hear a lot of back and forth about, what does unless mandated by law mean? The only exception would be if the annexation is required by state law, such as health hazard annexations. So I think really a lot of this is how is that interpreted? Was this strictly just meant to allow health hazard annexations, or was the emphasis placed on required by state law, such as an example, health hazards, right? I mean, so you'll see a lot of back and forth about how that's trying to be interpreted. That was actually addressed in the Benton County decision as well, because a lot of jurisdictions have that exact same language. I think it's Lake Oswego, and one other does not have that language.
Malala?
And it was addressed as well. So just a little bit more background that we were able to find since the packet went out. How would you like to you want us to help facilitate this?
Oh, I can facilitate just fine, thank you. So, does somebody want to talk? If you'll hit your button, I'll recognize you. Commissioner O'Donnell.
Well, I'll start it off. And there's nobody here that does not know I'm a home rule advocate. And has a long and storied history and is very well summarized in that League of Oregon Cities white paper on home rule origins, explanations, and future. And it's interesting, there's things in there that deal with preemption and when can the state preempt local rule. And of course, they can certainly preempt it in criminal cases because, you can't say in Oregon City only it's legal to kill someone. So that's common sense. We don't need to deal with that. But the other consideration was when you deal with preemption, it talks about of concern to the state as a whole. So I question whether this SB 1573 is constitutional on that basis because this is a local issue. And the state can say, well, housing and the provision of housing is a statewide issue. And my argument to that would be if it's of such great concern to you, why don't you supply any funds to help us with that situation? So I read, and I want to reference all these things for the record. I read that document, and I had read it before. In fact, I may have called it to Mr. Conkle's attention because it was of interest to me. And I read with interest some summaries that we received today from Mr. Nocita. And I'll say in response to Mr. Kabizman, my experience with the court system is they tend to focus on whatever the narrowest interpretation they can and what's brought before them. They don't expand it. So, the point was made that some of these things that would have normally be considered by the court, such as this phrase, unless mandated by state law, when we're talking about referring to a septic tank failure or whatever, I don't believe that was even allowed in the decision if I read Mr. Nocita's summary correctly. So that was excluded. And I know our charter says that. So I know we as commissioners are faced with the conflict between supporting our charter and believing this law is constitutional and supporting it. What troubles me up here is for 3 years I was told that we must comply with 1573. And within the last month we were in a meeting that said there were other options and potentially putting annexations on hold pending the outcome of this court decision. And that's news to me, and I never heard it. And another Commissioner Smith, who predates me, no, I don't believe he heard it either. So either I misheard it or I never heard it or it wasn't an option presented to me. So the quality of decisions made in this board are only as good as the options presented to them. So in the absence of all options, I would question any decision on any matter that we would make. And I find myself recently, wanting to ask staff, are there any other options available, at the end of a presentation? And I hate to do that, but I feel like I almost must anymore. So, I personally feel for the reasons cited in that white paper, for the reasons cited by Mr. Nocita, for the reasons endorsed by Mr. Buss, I am going to support the city charter regardless. And if that's an error, and as Mr. Kabizman so notably said, the decisions made in another jurisdiction are not necessarily binding on us. And, does that mean we have to go through the Clackamas County system? And what's that trail and what does that mean? So I've seen some creative solutions where annexations up to a certain size nobody had a problem with, but then major annexations were put on hold. So there's a lot to think about. I know I'm firing the opening salvo. I'm trying to encourage discussion from those that might otherwise sit silently. And with that, I'll yield the floor to whomever.
Commissioner Smith. You clicked your button.
I know, but I just am now reading this piece of paper with your name on it.
Absolutely.
Okay, so I just want to say that unfortunately I wasn't on the commission in the gap, the gap that I was on was when this issue came up. I know that if I was on the commission, I would have not supported the decision to follow the state's guidelines or rules. I think that definitely, I'm extremely disappointed in the past commission in not fighting and joining in on the lawsuit that other cities did. I think that was a mistake. And I've been vocal about that. It was one of the main campaign issues that happened just in the recent election, even though it was way past this decision being made. It was one of the main things that came up. And in addition to that, other issues as well involving development in this town. The voters were very clear in the last election what they thought about that. 2 commissioners up here were part of that old commission who made that decision. One of them chose to fight for the home rule of this city, and one did not. And what I guess I'm surprised by is the one that did not is one of the most vocal proponents of home rule in this city on every situation you can imagine, except for anything that involves development, which I find very interesting. And if you really think about why that is, you might have some answers about that or think about why that might be. And who was on the commission at the time and who was running for commission at the time and how they were connected with development. And I think that's something that really should still stick out to people. The unfortunate thing is even as early as January, when the new commission took office, we were not a full commission. And so some of these issues came up in the goals retreat. I want a transcript of the goals retreat because I think I brought this issue up at the goals retreat. But because we didn't have a full commission, there wasn't a majority really kind of take that up. At least I don't know. I really need to go back and look at what we have as a record for that goals retreat, because I think a lot of these issues were brought up, and what I want to really find out is why it has taken so long for us to really have this conversation. I can't say that it was brought up 100% on that meeting, but I'd be shocked that I didn't bring it up, because it was right after election that was very clear the direction that the voters wanted. It was after a commissioner resigned, and there were a lot of conversations in that goals retreat involving the rivers development, involving urban renewal, involving development and period, and so one of the things I'd like to do is get information about, listen to the tapes or whatever from that goals retreat to revisit the issues that I brought up at that time and why they went nowhere. I feel, conflicted on how to move forward because it is so late. And, clearly annexations have gotten through that we've allowed, or what the past commission allowed. But what's interesting is you look at that list of, 10 annexations that have gone through since. All of them are under 7 acres except for 3. And the other 3 are huge. And those 3 happen to be the three biggest annexations that this town has been fighting over for about 10 years. And that the citizens have completely, time after time after time, said absolutely not. And the people that didn't get elected, with the exception of the mayor, we're all tied to those developers in campaigns and support. And I just find that offensive. I don't know if we should, I mean, I know we have to wait for the outcome of this court case. It's too late for us to get really involved in it unless we choose to sue the state ourselves and go through our county courts, which I'm open to. But at the complete minimum, I think we do not allow any annexations in this town until we get an answer on this court case and we put a hold on them. That's at minimum, I think. Is this, well, I'll leave it at that and see what the rest of the discussion is. Oh, I have one question though. On number 3 on the list of annexations, number 3 is listed at 62 acres, and then in the text is 117, which is right.
My apologies, there was, the annexation of the Oregon City Golf Course was 2 annexations totaling 117. So together, 117, individually, that one was 62.
There's really 11 annexations?
I'll double check the list, but they had different annexation, I'll double check the list for you.
So if we got faulty information tonight, then that's not clear.
Anybody else? Commissioner Lawsmith.
I guess first I have a question for Mr. Kbeisman. Can you, to respond to Commissioner Smith's idea of not processing annexations, can you please provide comment on any outcomes of that or pros, cons?
Right.
Sure. I'll sort of do a general discussion, and if you have specifics, let me know. The statutes on land use, in particular, Chapter 227178, sort of set a deadline for when decisions have to be made. There's an expectation when applications come in, you're going to have to do certain things. The deadline that typically occurs for land use applications is 120 days. However, the Court of Appeals has made it clear that annexations are somewhat different than other land use decisions and aren't subject to the 120-day deadline. So if an application comes in, generally speaking, there's a duty to process it at some point, but there is no specific deadline of it must be done within 120 days. So what happens if an application comes in and somebody says, you know, when can we expect a decision? And the answer is, well, we're not really processing it. It's going to sit there. They're likely, I don't know, we haven't dug real deep into it. It depends on what sort of complaint was filed, but there's likely some type of mandamus action. A mandamus is essentially a mandate where somebody goes to the court and says, court, tell the government to do its job. And, you know, we would have the defense that, you know, there's not a 120-day rule, that we can't do our job because state law is unconstitutional and we won't follow state law. How all that would play out, I'm not certain. However, there is a potential that should we not process things, and the court tells us that we should have processed things, that there would be a risk of attorney's fees at the end for the people who being awarded against the city in favor of the complainant on that. And that's in addition to whatever costs the city incurs in defending it. And so there are some concerns. One of the things that would happen outside of that is typically you see annexations come in with multiple applications. An annexation with a zone change and a subdivision is a classic one. Though zone change and subdivision are both subject to the 120-day rule. So somebody could say, we need, we want an answer on those, let's take those apart. And the city's only possible answer at that point is denial, because we don't have authority because it's not in the city.
Can we require that the annexation be separate from the zone change and the subdivision?
State law requires that we allow applicants to make that choice. We can't say, you can't put these together. State law says we've got to allow a consolidated application for everything that comes in the door.
I mean, one option for the applicant too is probably to request Department of Land Conservation and Development to consider an enforcement proceeding.
Thank you. I'd forgotten that option. To the extent we engage in a pattern and practice of not following state land use laws, somebody could file a complaint at DLCD, and LCD seem to have an enforcement order against the city.
Yeah.
And that could result in loss of various state funds from different sources.
Well, thank you for the explanation. I think it's good that, if an option is on the table, that we hear all about it. So my comments on this topic in general, for me personally, I don't need to dive into the history of previous commissions and whatever their policy decisions were, or any theories on why they did what they did, because it doesn't affect our decision today. Today, we're being asked by other commissioners on this panel to reconsider whether or not this is a policy that we want to reconsider. And so, when I campaigned, one of the things that I campaigned on was reducing our legal fees. And this folds into that conversation because the fees for our legal team have had kind of skyrocketed over previous biennia. And so I think we've done a good job since January of trying to guide the work of our legal department in an effort to reduce the fees that essentially our taxpayers and residents are paying for. And so I have not supported to date, and I still don't support us filing or joining the City of Corvallis, just because I feel like City of Corvallis has their legal team supporting it. They have the League of Oregon Cities, filing briefs on their behalf. I think we're just spending legal fees, and because I really wanted to reduce our legal fees, I don't think a brief from us is going to make a difference in the case. If LOC and City of Corvallis can't cover it, then I'd be really surprised. So, so for those reasons, that's one reason I have opted for us to not jump onto and join the case, the City of Corvallis case. For Senate Bill 1573 in general, I actually believe, my opinion is that the state has the case. I think the Court of Appeals is going to uphold the local decision. That's my personal opinion. And therefore, I think we should just maintain our course, keep evaluating annexations. I don't like that the state decided to preempt home rule. I'm not happy about it. I'm happy that there is a city that was willing to lead the charge, and that League of Oregon City, and then that they're taking it to the Court of Appeals, and I fully support that challenge. But where I stand, I would like for us to continue following state law, which does trump local law, and move forward.
Commissioner O'Donnell.
I would say, when I watched candidates in the last election, those that got resounding support were those that supported home rule. But that's neither here nor there at the moment. I also would actually agree, I don't want to join the existing court case because the arguments within that are constrained by the existing arguments.
Well, it's too late anyway.
Regardless.
It's in the Court of Appeals, and it's already been heard, so there's no possibility of us joining that case, at least until after the Court of Appeals rules.
Well, as a commentary on why I wouldn't join an existing case, because it's constrained by the arguments that were made and as interpreted by the judge, what was admissible and not. As I said to Mr. Gebaisman, that courts tend to focus on the most narrow. It's unfortunate that the state mandates again that annexation, zone changes, and subdivision are all one and the same application, but that's a given. And I think we're going to face a similar situation, and it was in the newspaper today with Mayor Axelrod talking about the state now saying they want to put multifamily dwellings in single-family residences. So again, I have no objection. The outcome is if we say no to an annexation and people take issue against us, we could end up in court anyhow, whether we initiate it or we are the respondent to that. The only other thing I would say is, and correct me if I'm wrong, Mr. Gebaisman, if you had firsthand knowledge, is it not true that some jurisdictions are processing the smaller annexations and putting the larger ones on hold until the outcome of this court case?
I have seen some stories. I believe City of Silverton is one, and I've heard some rumors that Corvallis is sort of evaluating, but hadn't moved forward last I heard. Where what they've done, as I understand it, is tried to reach annexation agreements that laid out certain things that allowed them to move forward. I haven't heard of them specifically telling larger annexations, no, you're not moving any forward and we're not processing you. It is the most recent thing that I just haven't heard that. I can check with the Silverton city and see what exactly they're doing. But I think...
And I believe I read that article that Silverton was only processing annexations up to a certain size. And we're not saying we wouldn't process one. We're saying we want to await the outcome of this court case, which is so far overdue to having an outcome. It's ridiculous.
Yeah. Yeah, no, this is unusual. And at some level, we get used to the time frame of land use, which are expedited, and they come through pretty quickly. And so, if somebody were to ask me in a regular appeal, I would say about 12 to 18 months. And we're on the outside of that, and you just have no idea. There's no way to tell from us how close they are or what it is that's being held up. It could be some evidentiary dispute or something else. And I do want to focus a little bit on you mentioned evidentiary and just make clear that the language that the court talked about in Corvallis and Philomath is almost identical to the language that we have in our charter. The difference in the evidentiary, what happened was the city of Corvallis tried to put in affidavits from people who had been in the city of Corvallis when the measure was incorporated into the charter. And it was actually a citizen-initiated charter. And they actually tried to put in an affidavit from the city attorney who had discussions with the initiative folks, essentially saying, well, there's certain things that are mandated by state. You've got to allow them a health, and just to try to put in, here's what the voters thought they were adopting. And what the court said was, we don't really allow affidavits like that in to prove legislative intent. What we do is we look at what does the text of the measure say, what was on the explanatory statement, what were the arguments in favor and against. But, think about it on the city commission. If in fact you adopt a measure, it gets challenged later, what does it mean? And Mayor Holliday submits an affidavit saying, here's what I thought it meant. And Commissioner Smith submits a different affidavit saying, that's not what it meant. Here's what we meant by it. And what the courts have said in most cases is, we don't want to hear personal recollections of what you intended, because it can change, and what's in mind of one legislator might be very different than what's in the mind of the other legislator. And in that case, those citizen affidavits essentially are legislators, and they're not relevant evidence as to what the intent of the voters were. Sorry, that's a little long-winded explanation to try to get context.
It needs to be tonight.
Yeah, this was Silverton.
I read a number of excerpts, and some of them are from Mr. Nacita's, and they talk about how the court and I've been in court, sometimes when the court excludes evidence, and we've all been there, I mean, there's things that we'd like to get into the record and it's excluded, it would change the outcome of the trial. And that court that's held this hearing has excluded some key evidence that may not be excluded here. And I find it interesting, I'm sorry if you want to.
Yeah, I was just going to say that the court in Corvallis actually went and said, even if I'm wrong on this and would have let all this stuff in, it wouldn't have changed my opinion. So, you know, they kind of went forward.
Well, that's
and,
interesting.
Yeah, that's
It's like we didn't let
footnote
it in,
one.
but had we let it in, the outcome would be the same.
Yeah,
And I find it interesting, you know, it's always interpretation, both advocates like our community activists and our own attorneys read the same trial and come out with a different interpretation of what it means. In fact, you're quoted and actually in support of a position put forth by others in the community, which is contrary to what we're currently advocating.
Ask 3 lawyers the same question.
Well, usually you don't get a direct answer to start with.
I think what you were, Commissioner O'Donnell, you were referencing a resolution from 1709 from the city of Silverton, which includes, now therefore be it resolved dealing with annexations until such time as the legal conflict between Senate Bill 1753 and SDC Section 410-110 is resolved. City staff are directed to seek voluntary agreements
Is that at Silverton?
from annexation applicants authorizing annexation proposals to be submitted to the city electorate consistent with their code. When annexation applicants refuse to authorize the city to submit the annexation proposal to the city electorate, and the area proposed for annexation is greater than 2 acres in size, the city shall place a hold on a consideration of the proposed annexation for the sooner of 1 year after the date of said refusal or the final adjudication of Senate Bill 1573. So I think that's what you were referencing on the on hold part.
What was the response to that from the development community or for those seeking the development? Are they in court over it, or is it?
not that I'm aware of. I don't believe the city of Silverton has seen any large annexations proposed.
I'm done. Yes, thank you.
Commissioner McGriff.
Well, I also going to follow my colleague and not repeat anything unnecessarily, but I would have to say that my question, start out with a question, is that an annexation is a request by a party to the city. It's not, I don't see it as a guaranteed right that they have the right to be in the city limits. Is that, I mean, it's not saying we have to take everybody and anybody.
Yeah.
So I think when this measure was placed on the ballot, I think that there was many different reasons by not only the petitioners, but probably the people that signed the petition as to why they felt
What are you talking about?
when it was put on the ballot, there was a.
This was a referral from the city commission. It was not an initial petition.
But somebody filed it and asked the city to put it on the ballot.
It was me.
Well, it looks like it was John, you, and Eddie. So when this got there, there was some decisions made, and I think that there are certain things that come to a local government that I think the local government has authority over, and I would agree with Commissioner O'Donnell that I support home rule. In my previous role on a different commission, I probably voted against every single annexation, not primarily because of that charter amendment, not because I didn't think the development was good or bad. That was not the value judgment that was there. It's because we had said this is what we were going to do, and I felt it was my responsibility to uphold the charter. I still feel that way. I don't subscribe to Senate Bill 1573 the same way that I don't subscribe to House Bill 2001 for the very same reasons. So I would support us changing our policy regardless of what the state law says, because I don't believe that it's valid, and that if anyone wants an annexation, it needs to go to a vote of the people. And that's what we said we were going to do. So that's where I'm coming down on this.
Mr. Smith.
I agree with that, but I also want to thank Commissioner Smith for her input as well. The one thing I want to say, though, is it didn't save us any money from any legal battles, because we got sued because of this decision by the past commission. So it's not saving us any money.
What policy are you talking about?
You're saying we've been sued for approving annexations?
We're in a lawsuit.
There's
We're in several lawsuits.
We're in several lawsuits.
it was up in Park Place, so the developer
The
was
92 acres.
sued. We were a party to that. The developer takes the lead. We provide responses related to city applicable criteria.
Thanks for turning your phone off.
So,
It's only a single ding, unlike some people I know.
so can I have the answer to the development question that I had, the 63 acres versus the 117 acres?
Yes, my apologies. It was my error and my error alone. So in the list, it's number 3. It identifies an annexation file number, and that one had 2 ordinances. I pulled all the ordinances in compiling this list to come up with the acreage. So the acreage is only for one of the ordinance listed. In the body of the text that follows, it identifies the correct acreage, which is annexation of the Oregon City Golf Course, 117 acres.
So it was 117 acres, not 63.82.
Yeah, there was an ordinance for 63 acres and then another ordinance for 53 acres and change on both of them, so.
So it was 2 separate.
It was one annexation
So not
file.
only did the numbers get wrong, but you completely eliminated one whole
No.
annexation.
No.
Because where is it else on that list? It's not on that list. There's only 10.
No, it's the annexation file. So number 3 is for each, there's an assignment for each annexation file. So there's one annexation decision. That one annexation decision had 2 ordinances associated with it, and that was because of when, as a whole, the property came into the urban growth boundary. A little complicated. So the one annexation file had 2 ordinances. One of the ordinances was for 63.82 acres. Another ordinance was for 53 point something acres. So both of the ordinances are listed, and the description below, which says annexation of Oregon City Golf Course for 117 acres, is correct as a whole. What I failed to do was to list the acreage for the second ordinance that was listed. My apologies.
Yeah, but where here does it say in the document that you gave us that it's 2 separate annexations?
So
It's one annexation file, 2 ordinances. So there's one file number and 2 ordinances that follow it in parentheses.
What's the relevance here?
That we're getting accurate information to make decisions on from the staff?
Well, I think it's clear. There were 2 pieces of property that were annexed under the single
Well, it's
annexation.
clear now. It's not clear when we got the document from the staff.
Okay.
My apologies.
At all?
I'm not going to read this whole thing, but I want to read a couple lines from it. This is a document that was this submitted into the voters pamphlet?
Yes.
Put yourself in the picture. Support the charter changed for voter approval of annexations. It goes on to talk about citizens are the ultimate enforcers of growth limits and planning for the future. People who profit by growth, people who are not impacted by growth, or people who may or may not be hurt by growth are deciding how big. Choices are best when those who pay the price make the choice. Paid for by John Williams, Ed Alec, Dan Holliday. Boy, have times changed.
Absolutely. Commissioner McGriff.
I just have a couple more questions. So, Bill, you said that there's some requirement that we accept consolidated applications?
yes.
The reason that I asked the question is because I think it muddles the issues. To me, you've got an annexation, which is separate, and then you have the land use, which is separate. And I've not supported them being commingled because it just confuses everything. I think they need to be taken on their own merits for what they are. So you have an annexation over here and you need to take that on its merits. The land use application should be considered on its own merits as well. If the property does not get annexed, then you've kind of taken care of the second part of it. You don't need to have to consider that.
But you're saying state law says we can't do that.
That's correct. I'm trying to look,
Yeah, I mean, you said
I
something
understand.
that we allow them to choose to do this.
So what state law requires is that the governing body of the city shall establish a consolidated procedure by which an applicant may apply at one time for all permits or zone changes needed for a development project. The consolidated, it goes on.
Yeah, it says may.
We also have language in our municipal code
It
that.
says they shall.
Does it say
There's
shall
a
or
city
does it-
shall.
The applicant may.
So the applicant could choose to space them out, but
But they never do.
Well, it sounds like the city narrowed down the city says shall and the state says may. Is that correct?
No, the state says the city shall, but the applicant may choose to
Yeah.
consolidate or not.
So we constructed the shall language.
no.
No, this,
The governing body of the city shall establish, so the city has to establish, a consolidated procedure by which an applicant may apply. So it's, and there's a long body of LUBA and Court of Appeals where they say it's the applicant's choice. The applicant can choose to put them all of their eggs in one process or to space them out. And we process what comes in.
We do have provisions in Chapter 1750 of the Oregon City Municipal Code that encourage consolidation of applications, and the premise being, more when you can put all these pieces together. It helps the pieces fit, because often we'll get environmental overlays plus a site plan or something like that. So we do encourage it.
well, under the charter,
This is in general.
if an annexation is denied, which we've had several, then the other part's kind of moot,
Yeah.
correct?
If the annexation is denied, we have no authority to do anything else on the property.
Okay, well, that's kind of what I thought. Okay.
Commissioner O'Donnell.
So I'm going to wrap this up from me because I've had more than enough to say, but I do feel like previous decisions made by me were on the basis of incomplete information, that I would have made a different decision had I known other options were available. I struggle making a decision when a law is so close to being reviewed. And I think about other laws that have since been, and maybe they're applicable statements, but I mean, look at prohibition and what happened there only to be repealed. And look at our marijuana laws and the number of people who have suffered under those only to be rescinded or restated. So, I mean, how close can we be? I mean, how long can this thing drag on? Once we have an outcome, I'd like to work in accordance with wherever that is. And I know you don't have a crystal ball. I mean, it's just a general statement, and I'll leave it at that.
I think the one thing is just, we would I think we're anticipating it would go to the Supreme Court.
Oh, yeah.
So even though we might be close to the Court of
Certainly,
Appeals,
yeah.
I mean.
Yeah.
Commissioner Lyle Smith.
Thank you. I just want to make one statement about kind of a statement assuming that I'm not upholding the charter because I am saying that we move forward with the current policy as it stands now. My opinion is I read our charter. I feel like we do have clear language on what the plan was for annexations. The challenge for me is when I read our charter, I read the language that says unless mandated by law. And when I interpret that, that means unless we're mandated by law, which is state law. It's very, very clear. Unless we are mandated by state law, this is what we're going to do. And so that is my interpretation, and that's the reason I do feel like I'm upholding the charter, and I feel like with the way we're proceeding, I'm also upholding state law. So that's all I want to say.
Anybody else have anything else to say? Okay, then I'm going to take my turn. Commissioner Smith is absolutely right. I was the architect of this debacle, and if we cannot learn things over the course of our lives, then we are doomed to be stupid the entire time. So when this happened, it was I'd barely been a city commissioner for a year. First time ever being in elected office like the city commission, where you could actually make real decisions. And I read a book by, I think the guy's name was Evan Fodor out of Eugene, who was a very populist activist in land use policy back then. And he had advocated for this voter-approved annexation. And I thought it was a good idea. I brought it to the city commission. We talked about it. We referred a measure to the voters. The voters passed it. Fast forward into the age of Metro and the UGB. So now we're in a situation where, say, the Oregon City Golf Course or the annexations in Park Place are included in our allocation of land that is, quote, technically buildable according to Metro, but because it had been eliminated by the voters several times, so we have this situation where we have all this land that they say we can build, so it forbids us from being able to expand our urban growth boundary to a place that maybe we could build. And so we're stuck. So the two things are fundamentally oppositional to each other. The Metro Urban Growth Boundary, SB 100, and all of that land use policy is fundamentally opposite of voter-approved annexations in cities, because they work to opposite ends. And that's why, yes, I supported, I went down to the Capitol and worked for 1573, because I think I was wrong in 1999. And if we can't say, and I think most people know this about me, if I do something wrong, if I make a mistake, I'm willing to stand up and say, I made a mistake, I'm sorry, we'll fix it. So that's my reasoning behind supporting the voter-approved annexations. I am willing to compromise to the point of saying we're not going to process any more applications for annexation until the courts have resolved, at least until the Court of Appeals has resolved the situation. I'm not willing to get into another expensive lawsuit with the state over this when it's already winding its way through the court anyway. And I'm happy to abide by whatever the Court of Appeals and the Supreme Court says. But at the end of the day, as Commissioner Lyle Smith says, state law is state law. It was passed by the legislature, signed by the governor. And according to the way I read the charter, we have to abide by state law. And just because we don't like it doesn't necessarily mean that we can just say, whatever. And to end my statement, I have tremendous amount of faith in our legal team. Not so much the outside lawyers that are coming in and flying in the face of everything that we try to do. With that, I think we're done with this, and we can, obviously, we're going to have to make a decision in a public forum at some point.
Yeah, I think you've got, when we move into the public meeting night, you do have an annexation. We can talk about it again there during that application.
All right, then we're adjourned.